To all my we the people in the house, this is another public announcement from the United States Private Enterprise Free State. And you see the title, it's titled The Infant Estate. And this is what we're going to be talking about real quickly. We have consultations 407 300 5377. The term infant estate has a specific legal meaning that is different from how the word infant is used in everyday speech. In U.S. law, including New York law, an infant is a person who has not yet reached the age of majority, generally under 18 years old in New York. An estate is the property, money, rights, and legal interests owned by a person. Okay? Owned by a person. Okay? My people. Okay? Now, an infant estate my people, an infant estate means the property or assets owned by a minor. Examples include an inheritance left to a child, money received from a lawsuit settlement, real estate titled in a minor's name, investment or bank accounts owned by a minor. Because minors generally cannot legally manage their own property, a court may appoint a guardian of the property, also called a guardian of the estate in some jurisdictions, or another fiduciary to manage the assets until the child reaches adulthood. Once the person reaches the age of majority, they generally gain the legal capacity to control their own property unless a court has ordered otherwise for a separate legal reason. If you're asking about infant estate in connection with a birth certificate, trust, or New York property law, let me know the specifics, what you need when you get this consultation, my people. Now, Article 17, okay, in Senate.gov, basically, there is no Article 17 in the U.S. Constitution. The Constitution has 7 articles, Articles 1 through 7. After those are the constitutional amendments, including the 17th Amendment. The 17th Amendment provides the Senate of the United States shall be composed of 2 senators from each state, elected by the people thereof for 6 years, and each senator shall have 1 vote. It also provides that each state elects 2 U.S. senators. Senators serve 6 years. If a Senate seat becomes vacant, the Senate executive authority may make a temporary appointment if state allows until the vacancy is filled by election. Now, Article 17 of another law treaty, the UCC, or New York law. Now, in legal documents, the word praying does not usually refer to religious prayer. It has a specialized legal meaning. Legal definition for praying, requesting, or formally asking a court or other authority for relief. Seeking a specific order, judgment, or remedy. Petitioning for a legal action. For example, if a statute says a verified petition praying for registration, it means a verified petition requesting or asking for registration. Similarly, the petitioner prays for relief, means the petitioner is asking the court to grant the requested remedy. Prayer for relief is the section okay, hold on, my people. Got a slight interruption here. Prayer for relief is the section of a complaint or petition that states exactly what the person wants the court to order, such as money, damages, an injunction, or declaration of rights. In modern legal drafting, words like requests, seeks, or ask are more common, but prayers and praying still appear in statutes, court rules, and older legal forms. So, 1731 from the Senate.gov. Infant, incompetent, or conservatee. Award of court from the time of the filing of a petition by or in behalf of an infant, incompetent person, or conservatee praying for an order to dispose of this real property or interest in real property. The infant, incompetent person, or conservatee is considered a ward of the court with respect to that real property or interest and the income and proceeds thereof. The court shall have power to make such orders as may be necessary to further justice and to protect and conserve the rights and interests of the infant, incompetent person, or conservatee. The provision means that once a qualifying petition is filed, the court assumes authority over the real property involved in that proceeding to protect the interests of the person who may not be able to protect their own interests. Infant means a minor, a person under the age of majority. Incompetent person means someone whom a court has determined lacks legal capacity to manage their own affairs. Conservatee means a person who is under a conservatorship where recognized by law. The key sentence is from the time of the filing of a petition praying for an order to dispose of his real property. This means that after someone files a petition asking the court for permission to sell, transfer, mortgage, or otherwise dispose of real property of an infinite incompetent person or conservatee, the following happens. The person becomes a ward of the court with respect to that real property. The court gains authority to supervise decisions involving that property, its income, and its proceeds. The court may issue orders necessary to protect the person's interests while the case is pending. Importantly, this statute does not mean every minor is automatically a ward of the court. It applies only after a petition of the type described has been filed and only with the respect to the real property involved in that proceeding. So, birth records or an infinite estate. So, my people, You know, this is coming out of a section, 370 in the Senate.gov, okay, of New York real property law, okay, Article 12, and it describes who may file a petition to register title to real property under New York's Torrens registration system. Here's what each part means, my people. So, if you're not tuning in now, you will tune in because I'm the only person, the only motherfucker out there, the only mastermind out there giving you the real truth where you won't waste your fucking money. So, real property or any estate interest or right therein. This refers to land or legal interest in land, such as ownership, a life estate, an easement, or another recognized property interest. By filing a verified petition praying for registration, a verified petition is a petition signed under oath. Praying for registration means formally requesting that the court register title to the real property, which is done down at the registrar's office in vital records with the clerk of the county in which the land is situated. The petition must be filed in the county where the land is located. The petition may be so made in person by the owner. The owner may file personally or by an agent acting under a power of attorney. If the owner cannot file personally, an authorized agent with a properly executed power of attorney may do so. A corporation may also apply by its duly authorized officer or agent. A corporation can file through someone authorized to act on its behalf. An infant or other person under disability may apply by his legally appointed guardian, trustee, committee, or conservator. Here, infant means a minor under 18. A legally appointed guardian, trustee, committee, an older legal term for a court appointed fiduciary or conservator, may file on behalf of someone who lacks legal capacity to file personally. The natural person or corporation may be known as the petitioner. The person or corporation filing the petition is called the petitioner. Other parties in the case are called defendants. Now, if this applies to a birth certificate, no. This section is about registering title to real property, land. The references to an infant guardian or trustee simply identify who may file a petition when the property owner is a minor or another person under under a legal disability. The statute does not state that a birth certificate is a certificate of title, that a birth record is real property, or that it creates a title to land. It is not it's not a SPV. Okay? A birth certificate is not an SPV, my people. You can look it up for yourself. So people who are telling you that a birth certificate is a special personal vehicle or SPV, it's not. Now, if your interest is how Article 12 and the former Torrens registration system works, give us a call, 407-300-5377. So, A birth certificate is not a security. A birth certificate cannot, you cannot put a CUSIF, you cannot assign a CUSIF number to a birth certificate. You can't do none of that. And the people that are telling you that you can, ask them to give you proof, show them, ask them, can I see your paperwork where you have done it on the record and that you're using it to do everything that the CUSIF number is supposed to do for your birth certificate, including discharge your debt. If they can't prove that, then you need to leave them alone because basically they're scamming you straight up. That's the bottom line. And that's real truth to all my dummies, you know, the birth certificate for dummies. Straight up. So my people, we the people, this has been another public announcement from the United States Private Enterprise Free State. 407 300 5377. Get a consultation, get into these classes to start building your foundation so that when you do start filing paperwork, you won't get locked up. Stay up, stay one, stay strong, and we are out.